Kibiki is such a unique situation in the sense that it really was, for so many people, emblematic of everything that the missing murdered women and girls inquiry was all about. So we really had a responsibility, I think, obviously to ensure that the accused in that case had a fair trial, but we also had a responsibility to ensure that deeply felt trauma by all the victims' families, but also the larger community, was properly addressed in a trial. There was present in the courtroom, certain things that I think were meaningful, not just for what it was representing in terms of the legal issues, but also for our court's efforts at judicial reconciliation.
You mentioned it, the National Inquiry legal document. I want to speak to certain calls to justice and how you're trying to implement those here.
We have to be humble with respect to how much we can do in responding to some of those recommendations. The justice system obviously involves many actors, so we're not involved in the investigative role, we're not involved in the prosecutorial part of things. We simply adjudicate, we judge, we assess, whether it's a judge alone or with a jury. But to the extent that those cases come to us, I think we have a real responsibility to ensure that we handle them as quickly as we can, but also if we're not dealing with them in a way that's sufficiently, I think, sensitive, empathetic, and responsive to what are the unique challenges facing that type of investigation, that type of prosecutions.
The Woodhouse, his conviction, 50 years. Talk about that trial and the injustices.
Well, it's a tragedy. So when it happens because of bad identity, a lack of disclosure, the way the case might have been prosecuted, or the way the case might have been adjudicated and judged, that's not a good thing. Well, the same case involving, I think, Mr. Woodhouse's brother 2 years ago. Those are cases for which the system has a hard time offering an explanation. One of the ways we have to do that is when we see cases that can be identifiably called systemic discrimination, we have to call it out, and we have to address it, and we have to apologize for it.
What are some of the changes you've implemented generally, but also, in relation to Indigenous people?
So in every area where we've tried to make improvements, and they don't just relate to the Indigenous communities, but a lot of them do, we've tried to make things less costly, less complex, and more quick. One is child protection. The Family Division brought in some very important reforms that, in the context of these tragic apprehensions, sped up the process because it was happening for too long. Is a situation where these kids who were apprehended were in limbo, sometimes for 24, 36 months. And bad things happen when children are apprehended and they remain in limbo. Phoenix Sinclair is a good example, right? Similarly, in the criminal law, we've tried to do that as well. Because as you know, unfortunately, it's more likely once an Indigenous person is arrested for that person to be denied bail. They don't get out. So the socioeconomic realities make it much more difficult for them to get out on bail pending a trial. 2017, where I struck a committee, it's called the Trust, Reconciliation, and Access to Justice Committee, so it's TRAC in short. This is a committee made up of about 7 or 8 judges and now 5 community members. Some significant participation by Indigenous community members. We're educating ourselves about Indigenous legal traditions, Indigenous legal orders, those things that I think are increasingly part of what it is Indigenous leaders and Indigenous communities want us to understand and in fact incorporate and integrate to the extent we can into our own processes. As well, the education is basically exposing ourselves to individuals who come and teach us and talk to us. Nagan Sinclair, for example, came and did a half morning on UNDRIP. Judges were very interested and very engaged. We're not doing enough sort of in community or on the land training yet, but we're planning that as well. The other 2 pieces are big systemic change and smaller systemic change. A good example of that is what we did 2 or 3 years ago when we brought in the Eagle Feather. Really meaningful, I think, step, but it wasn't done. The bigger systemic change involves ways that we might collaborate with or sometimes get out of the way of initiatives that are being brought by Indigenous communities in respect of ways they're assuming now what they believe is their own jurisdiction. And you're going to start seeing more and more of that, I think, in child protection. And you're going to start seeing the development of that as various courts, including the Supreme Court of Canada, address the extent to which Section 35 and the Indigenous right of self-determination plays out and evolves in a fashion that's going to require courts maybe to re-examine how we either work with, collaborate, or coexist with Indigenous justice systems and certainly Indigenous legal traditions.
Let's talk about UNDRIP. From your perspective.
Well, UNDRIP is a thing. It's now been adopted in a way in Canada where we as a judiciary have to deal with it and have to understand it and understand that it's going to have implications for how we interpret our own governing law. We're going to be even better placed, I think, able to bring a perspective that will better reflect what it is we have to do when we're dealing with issues that touch Indigenous issues, whether it's a duty to consult case, whether it's a matter in the criminal realm, or whether it's a matter respecting a child welfare issue. All of that is now going to play out in ways that I think are going to be in some way connected to the broad principles and ideals of UNDRIP. So we have to deal with it.
Thank you, TR, for the highlights of that sit-down interview with Chief Justice Doyle. If you want to hear more from their conversation, the full sit-down interview can be found on APTN News YouTube channel.